Oh, ground. Yes.
Adjournment request, if any, from item number 1 to 5. From item number 6 to 18, adjournment request.
Please, Your Lordship, with
Yes.
respect to item number 6, we have filed our additional affidavit.
Item number 6.
Item number 6.
Yes.
That is not on record, Your Lordship.
As prayed for on behalf of the appellant / Union of India, re-notify after 3 weeks.
May we serve the copy?
Lordship, I will serve the court. Much obliged.
17 October.
May it please your lordship, I beg to mention item number 17. Lordship,
1/7.
179.
Yes.
Lordship, we were supposed to serve the extra copies, my lord. It was not served. I will serve it today itself, my lord. Extra copies of the expedition.
Alright.
To the SP.
As prayed for on behalf of the appellant, re-notify. Then it goes after 2 weeks.
Any date, my lord, if any date. Much obliged.
15 October.
Much obliged.
Obliged, Lordship.
Yes.
May it please, Your Lordship,
Yes.
I beg to mention WBC 20/2025 for listing, Lordship. It was last posted on 23/4/2025 and Honorable Court give direction to list the case in due course, Lordship.
What is the matter?
Lordship, matter in this case, we challenge the Lordship rule of the Constitution of the autonomous, North Kasar's autonomous district, Lordship.
It's at any time. October. Give a date.
Yes.
Obliged,
16 October.
obliged.
May I please?
Yes.
Your Lordship, I beg to mention item number 18, Your Lordship. Kindly, this matter may be transferred to Itanagar bench, Your Lordship.
Why?
Your Lordship, there is a regular sitting of division bench in the Itanagar itself. Earlier also, I have filed applications, but the same has been.
Is the bench available?
Yes, Your Lordship.
But have you informed the other side?
Yes, Your Lordship.
It's okay, you have no objection.
No.
What is your name, Mr. Counsel?
Idak Bam, Your Lordship. I Bam, Your Lordship.
Mr. I. Bam, learned advocate for the appellant.
For the respondent number 5, Your Lordship.
Learned advocate for respondent number 5 made a request for transferring this matter to each another bench as a division bench is already functioning there. Considering such request, for which there is no objection on behalf of the appellant, the matter, we direct that this matter be transferred to the each another bench before the existing division bench, where it shall be heard on a date to be fixed by the division. All right.
But instead of transfer, it could be expedited.
We have said that you can always, in the garb of this order, you can always mention before the division, right?
Right.
That date shall be fixed.
Much obliged.
May I please, Your Lordship?
Yes,
I beg to mention item number in respect, item number 10, my lord.
yes,
One relevant documents should be part, maybe part of.
what
The-
relevant document? You don't want to argue it today, you say that you want an
No, actually,
adjournment.
my lord-
What relevant document? This court is always ready to accept documents
No, my lord.
across the board.
File additional affidavit, my.
You have filed an additional.
Additional, yeah.
When did you want to file or you have
Two-
filed?
2 days, my lord, requirement, only 2 days.
If it does, if you don't argue today, it goes after in October. Again, learned counsel for the appellant seeks some time to put in additional affidavit so that the case could properly be, so that the appeal could properly be appreciated. Let this matter come up for consideration on
24/10.
Yeah, much of it.
Any other request for adjournment?
Yeah.
Any other requests? Daily list for orders item 1.
Maybe, Your Lordship.
affidavit from respondent number 5 has not been received. Who is respondent number 5?
Deputy Commissioner.
May kindly grant me, the affidavit is ready for querying. The Lordship may kindly grant me if you did that.
You are appearing for which part?
Respondent number 5, method.
All right. So we pass it over
Yeah.
tomorrow. That's Monday.
Deeply obliged.
Monday.
Obliged.
8 September. Item number 2.
Yes,
No one has appeared for response number 1, my lord.
do we wait for another occasion?
But in any case, the connected retrievals are listed tomorrow for hearing, my lord.
Okay, is it tomorrow? Tomorrow, that's Monday.
Tomorrow, my lord. Item number 13 to 42, my lord. The connected retrievals are.
Where is it? So it is coming when? Tomorrow. Tomorrow?
13 পৰা 42 লৈকে series এটা আছে।
All right, place it along with it.
Tomorrow. Item number 3.
Here, my lord, delay of 385 days in preferring the.
May I clear the topic? What I am appearing for the private respondents, I have already filed in an affidavit,
You have filed an affidavit. What do you say?
but the same is not on record yet.
Like here, let counsel for the respondent submits that the affidavit in opposition has been filed, but the same is not on record. Let the registry place the same on the next date. We notify on your date up 2 weeks.
17/9.
Obliged, Lordship.
Item number 4.
Here, my lord, delay of 81 days, my lord.
How many days?
81 days, my lord.
I have filed the objection, my lord.
Yeah, for the reasons stated, we have heard so also for the condone the delay. The registry is directed to process and list the writ appeal. The writ appeal.
Obliged, lordship.
Some urgency is there, my lord, early.
How will it be listed? Admission September. September.
22nd September.
पूरा detail लिख देना like yeah.
Item number 5.
Here, my lord, 54 days delay, my lord.
Somebody is appearing.
First time, my lord. I am appearing for response number 3 to 12, my lord.
What do you have to say? You want to file and. Notice to whom?
1 and 2, my lord. No, 3.
Like, yeah, there's an application
Three अपनी पे हो।
combination of work, so dates in preparing this appeal. Who appeals? Mr. Khatiniar and Mr. Bora has accepted notice on behalf of.
I am for the appellant, my lord.
Oh, he is for the applicant. Who is this?
I am for the BPC for response number 329 and SSA.
So-and-so has already
10 to
appeared for
12.
response number 3, response number so-and-so. Let notices go to response number 1 and 2 or steps being taken by the applicant, applicant within a period of 1 week,
Yes,
both
ma'am.
modes returnable on your date in late October.
And 13 by CGSE, my lord. Obliged, lordship.
13/10. Item number 7 for admission.
May I please, your lordship? My lord, this case is relating to lordship, non-completion of a construction of roads, lordship.
Yes.
What happened, lordship? Lordship, there is a lordship stretch of road, lordship. From that would be start from Cheragi Bazar to lordship Jagdishpur Part 5.
Yes.
There is a 1.5 kilometer lordship stretch, lordship.
Yes.
So, lordship, the government of Assam, lordship, issued an NIT for construction of that roads, lordship. Accordingly, the order was awarded to respondent number 6, lordship, for construction, lordship. But when the respondent number 6, lordship, started the construction, lordship, he started from its ending point. Admittedly, there is a canal, lordship, which obstructed the construction, lordship, at the starting point of that
So
road.
it's not yet been completed.
Sorry, lordship? Yes,
It
lord.
has not yet been
He had been
completed.
completed, lord.
Yes, what do you have to say?
Please, the-
My lord, I appear for the respondents, my lord. The lordship may grant us some time, my lord. I have to take instruction in the matter.
No, not all respondents would be answering respondents. I think you'll have to seek instructions from respondent number 5 and
Five.
6,
Five,
the contractor, because
six,
that's
six is the contractor, five is the authority. Three and five, but three and
Mr.
five.
Nath.
Not-
But you appear for all the respondents.
Yes, not except six, not 1 to 5.
Private.
Mr. Nath, learned counsel accepts notice on behalf of respondents number 1 to 5.
5.
And submits that the response to the petition shall be filed by the next date. The contention in the writ petition is that despite the work order having been issued to respond number 6, the construction of road from Katigora, Harinagar at Chirangi Bazar to Jagdishpur, PT5 has not yet been completed. The respond number 6 actually started the project, that is construction of road, from the end extremity, ostensibly on the ground that the beginning of the road was a canal and it would have required a lot of expenses to fill it with earth. That would be no justification for not completing the work. The progress of the project, according to the writ petitioner, stands only at the stage of 36%, but no action as yet has been taken. The affidavit filed by Mr. Nath shall contain the response to the aforenoted submission of the writ petition. Let notice also be issued to respond number 6 on steps being taken by the petitioner within a period of 2 days, both modes, returnable on the same date.
2210. Item number 8.
That's
May please, Your Lord.
Keep the names I forget. Yes, yes.
The impugn order herein, my lord, was passed relying on a judgment and order in a writ petition, as well as interim order in writ appeal. And that writ appeal finally culminated into interfering with the honorable single judge's order. So in that view of the matter, my lord, this impugn order at page 97, it has become unsustainable in the eye of law, my lord. Page 97.
The order dated 29
29
23.
Yes, ma'am. WPC 1607/2020.
The other side has to be heard. You
Yes.
understand?
Yes,
Let notice be.
but I'm praying for a stay of the impugn order.
Where is the division bench order? Have you
Yes,
placed
my
it?
lord. Division bench order, your lordship will find 102, page number.
All right. The Assam Power Generation Corporation Limited. Class appellant. He should have gone there. This is, but Mr.
Das.
Mr. Das,
Yes.
my brother is correct. Why can't you file a petition in that writ petition, application in that writ petition only? It will be closed on the basis of that.
No, disposed of, my lord.
It's a dispose. It's the
Yes,
dispose of.
learned single judge by this impugn order will dispose of the writ petition during the pendency of the writ appeal, relying on the interim order pass and the honorable single judge's order.
Or the Assam Power Generation Corporation Limited has challenged the order dated 29/9/2023, passed by learned single judge of this court, directing that the respondent's entitlement as pensioner under different heads as per Rule 4 of ROP Rules of 2017 would be assessed, and if the respondents are found to be entitled for any enhanced amount, the same shall be paid expeditiously and within an outer limit of 3 months from today. Stop. It was also directed that in terms of the order of a division bench of this court passed in WA number 107 of 2023, before the receipt of the enhanced amount, if any, the respondent would be required to submit an undertaking that in case the issue is finally resolved in favor of the corporation, he shall refund the excess amount. Stop. Mr. Das points out that the order impugned was based on an interim order passed in WA number 107 of 2023, which stands dismissed, which stands allowed or dismissed.
Dismissed.
No,
Because
no,
writ
you were
appeal
the-
dismissed. So
You were the appellant there, no?
yes, my lord, writ appeal got dismissed. So increment or whatever passed earlier that got merged with.
No, writ appeal was allowed.
Oh, I'm sorry. I'm so sorry, my lord.
Writ appeal was allowed.
I'm sorry.
Okay?
Allowed.
But has informed that finally writ appeal number 107 of 2023 has been allowed, extinguishing the claim of such employees who are similarly situated to the respondent here in this appeal. Let notice be issued to respondent number.
One, my lord, sole respondent.
Let notice be issued to the sole respondent on steps being taken by the appellant within a period of 2 weeks, both modes returnable
My lord.
on so and so day. In the meantime, the operation of the issued order shall remain stable.
2710.
27.
Item 9.
Yes. Yes, Mr. Boyle.
My lord, may I please as a lord? So, my lord, the matter relates to, my lord, provincialization of the services of the present appellant as well as, my lord, the private respondents, my lord. My lord, what has happened, my lord, as per the provision of the section 3, subsection 1, clause 11 of the, my lord, the Vansar Educational Institution Provincialization Act, only 3 teachers, my lord, in these categories of upper primary schools can only be accommodated and provincialized, my lord. And accordingly, my lord, after a long, my lord, scrutiny and examination, my lord, the district level scrutiny committee, my lord, did recommend me, my lord, in the subject of social studies for the purpose of provincialization, my lord. And yes, my lord, my provincialization order, my lord, may be pleased to find is at page 59 of this
That's
memo.
all right. So what happened there?
So, my lord, and thereafter, my lord, a series of petitions has been preferred, my lord. In those petitions, my lord, there were several directions were issued. And accordingly, my lord, a direction was issued by this honorable court, my lord, wherein the entire teaching and non-teaching staff was directed to be, my lord, re-evaluate again by the district level scrutiny committee, my lord. But without doing that, my lord, only the present appellant's case had been, my lord, re-evaluated or re-examined. And thereafter, my lord, I had been held that, my lord, is not to be improper. My seniority is not coming into the position for my provincialization, my lord. So that was the minutes, my lord. But those decisions had been put into challenge before the honorable learned single judge, my lord. And the learned single judge has dismissed the petition with elaborately discussing only on the ground, my lord, that as the seniority is not coming in my way, my lord, is not coming in my rescue. So therefore, my lord, the interim the impugned minutes as well as the orders cannot be, my lord, interfered with, my lord. That is my case, my lord.
The impugned judgment says
My lord.
that you had filed an affidavit that you were.
My lord, that has been quoted. Yes, my lord, that has been quoted for that, my lord, for that query, my lord. What my respectful submission, my lord, is that, my lord, every teacher's individual is required to furnish a prescribed form, my lord, along with those affidavits, my lord, before the district level scrutiny committee. Now, in that prescribed form also, my lord, I have said that as I am teaching all the subjects, being in the capacity of the headmaster, so, my lord, in any category I can be fit into, my lord.
That's something different. But here is a question of, inter-se seniority. So he goes in a different subject, you are in a different subject.
My lord.
So it's all about subject
No,
matter.
my lord, the inter-se
So tell
seniority.
us where the single judge has gone wrong.
My lord, the learned single judge has,
That's
yes, my lord.
based on your admission.
That is correct, my lord. There was an affidavit.
No, my lord, what was there, my lord, apart from that, my lord, apart from that, my affidavit, there was a direction passed by the learned single judge, in this matter, my lord, by another learned single judge. For that, my lord, I beg to draw my lordship's attention, my lord, to that order also. It has relevance with this case, my lord.
Purpose.
My lord, the purpose, it is connected with one another, my lord. That is the reason, my lord. If my lord may be pleased to take up. At page 55, my lord. Page 55 is the third round of litigations, my lord. In page, the writ petition is filed by the petitioner, because, my lord, in this petition, I was not the petitioner, my lord. It was by the private respondent in my case, my lord. What has happened, my lord? In this petition was disposed of without hearing me, my lord.
No, no, not correct. Immediately dismissed. No, but under the orders of this court where you were not heard,
My lord,
the DSC Golpara was examining and reviewing the whole thing. Did you appear before?
No, my lord, I was never been summoned, I was never been, my lord, given the opportunity to place my case, my lord, before the DSC, my lord. Had it been a case, my lord, then I could have satisfied, my lord.
Only for that purpose we are issuing notice. Huh?
My lord, my lord,
Otherwise, you don't have a case. We will find you with
My-
your affidavit.
my lord. That is there, my lord, that I cannot deny, my lord, that is there, my lord.
The appellant has questioned the judgment dated 10/4/2025, passed by a learned single judge of this court, whereby the contentions raised on behalf of the appellant have been rejected, and the petitioner continues to be held as junior to respond number,
My lord, herein is respondent was 6.
as respond number 6. The short facts which has left the filing this appeal are that the appellant was provincialized. The appellant's services were provincialized
Mild.
as a tutor sometimes in the year 2021. And since then, he has been serving in that capacity. Prior to that, he was appointed as headmaster of KB Memorial MEM on 16/1/2006, where he joined services on 18/1/2006. In that college, in that madrasa, respondents number 6 and 7 also were appointed as assistant teachers. under the Assam Venture Educational Institutions Provincialization of Services Act 2017. The process of provincializing the services of teachers began. The DSC, the District Level Selection Committee, Golpara, which had convened on 9/6/2018, had recommended both the appellant and respondent number 7 for provincialization as tutors, in which the appellant was recommended for the subject social science, whereas respondent number 7 for languages. These recommendations were based on student enrollment and teaching subjects. The appellant had a BA degree, who had been teaching all subjects, was found to be more qualified for social science, while respondent number 7 was only had only a higher secondary degree, and therefore he was not recommended for provincialization for social science subject. This decision of the district level selection committee, was challenged by respondent number 6 before the educational tribunal and later before the High Court. His claim was ultimately rejected. But then again, he preferred a fresh petition, which was disposed of with a direction to respondent number 1 to consider the appeal which was pending, appeal preferred by respondent number 6, which was pending at that time. It appears that in compliance of the aforesaid order, before passing that order, no, in compliance of the aforesaid order, the respondent number 1 acted with dispatch and passed an order on 22/2/2024 without hearing the appellant, even though the High Court's direction was to hear all the parties concerned. By the aforenoted order, the respondent number 1 directed the DSC Golpara to re-examine and review the recommendations for provincialization at KB Memorial MEM under 2017 Act. Thereafter, the DSC was held on 23/7/2024. And in resolution of the said meeting, respondent number 6 was held to be senior to the appellant and was recommended that he be extended the benefit of provincialization as tutor for social science. This was challenged by the appellant before the learned single judge, who dismissed the writ petition on several grounds, but primarily on the ground that that in the proceedings before the authority, the appellant had stated on oath in his affidavit that he had been teaching Assamese subject and not social science. The court, therefore, the learned single judge, therefore, did not find it necessary to reopen the issue and find out whether respondent number 6 was teaching social science subject. The entire decision of the learned single judge rested on the affidavit of the appellant in the proceedings. There would be no quarrel to such finding, but the objection has been raised on behalf of the appellant on the ground that the resolution was passed without hearing the appellant, even though there was a direction of this, there was a direction of the High Court to hear all the parties before deciding the issue. Let notice be issued to respond number 6 on steps being taken by the appellant within a period of 2 weeks, both modes returnable on so and so date. Mr. Khataniar accepts notice on behalf of rest of the respondent and shall file his response to the petition if so deemed necessary.
Lord, there was another.
We'll have to issue notice to 7.
Seven also, my lord.
Let's notice be issued to response number 6 and 7.
Obliged.
22nd October.
Well, highly obliged.
Item number 11.
Yes.
Before my thing start, my lord, I am appearing for respondent number 1 in this case, my
Who
lord.
is the respondent number 1 in this case?
Petitioner in the case, my lord, original petitioner, my lord. The order was in
It's an
favor of the
appeal by
original
state. Yes,
petitioner.
yes.
But I have not got the copy, my lord. I have.
How is that
No,
possible?
it is not possible, I understand, my
No,
lord.
no, how is that possible?
No,
It will not be listed.
I had not filed caveat. So it was,
Oh,
Yes, that is
we had a different system. The
Yes.
moment you file an appeal, the registry would ask you to serve a copy to the other side and bear a certificate. This practice is not followed here.
Not for a year,
Therefore, without serving a copy, a matter cannot be processed.
your lordship, the persons concerned have to file a caveat, lordship.
that is the, I have not filed a caveat, that is the.
That's all right. So you have filed a caveat, give him a copy.
Lordship, I will provide any day, lordship, he can give
Yeah.
it, lordship, he can give it.
What is his name? What is your name?
M.K. Mishra, my lord. Manoj Kumar Mishra.
Mr. M.K. Mishra, learned advocate for respondent number 1, submits that he has not yet received a copy of the brief for addressing this court. Let a copy of the entire brief be served upon Mr. Mishra by the counsel for the appellant within a period of 2 days,
Lordship,
whereafter this matter shall be listed under the same heading on. Give a date.
27 October.
October,
27.
before vacation,
Before that,
before vacation, lordship.
do it
Before
in September for it. It's all right.
My lord,
Simultaneous
24.
degrees.
Lordship, lordship. That's prohibited under the UGC also, even lordship, PhD
24.
cannot be allowed, lordship. Even 2 degrees can be allowed after 2022, PhD is barred, lordship. PhD cannot, lordship.
Is there a specific prescription?
Lordship, when the UGC's regulation itself,
You did not show it to the learned single judge.
lordship, we have shown it, but it does not.
Where is the discussion?
Lordship.
Therefore, the necessity of giving the copy is
Paragraph,
all this.
paragraph,
You could have decided it just now.
paragraph 9, lordship. We'll provide them copy, otherwise paragraph 9, lordship.
Paragraph 9.
Paragraph 9, lordship. 119 page, lordship. It starts from 120, lordship, first line, the second issue, lordship.
But then she was already enrolled, no?
Lordship,
She was already enrolled.
already enrolled, but lordship, that cannot be, lordship. Even he pursued a PhD, then lordship, he cannot pursue the MCOM, lordship.
How is that possible? So if UGC was beyond any, cavil by the universities, I
Lordship,
think that
UGC
should have been taken into account.
Somehow UGC's lordship stand was misquoted in the order, lordship. As because UGC itself says that lordship it cannot be. Even one person,
What is the relevant part,
Lordship.
relevant instruction of the UGC?
lordship, lordship.
It's for our interest.
Lordship,
therefore
it
we are
is
hearing.
page 73, lordship, page 73, lordship.
Page 73.
Guidelines, lordship. This was came for the first time in April 2022 and notified in September 2022, lordship. Guidelines, lordship.
Read the guidelines.
Guidelines, lordship. Directly I come to
Page 73.
guideline 5, lordship. These guidelines shall came into effect from the date of their notification by the UGC. No retrospective benefit can be claimed by the student who have already done two academic programs simultaneously prior to the notification of this guideline, lordship. Then, lordship, the above guidelines shall be applicable only to the students pursuing academic program other than the PhD programs, lordship.
That means, my lord, this regulation is not applicable in these instances.
All right, you'll have to explain that.
Next.
Otherwise,
And
there is no provisions for dual degree prior to 2022 by the UGC.
No.
As per the NEP.
Here, my lord, I must clarify, my learned friend has misquoted this. Because of the fact, this regulations came into place in 2022. It clearly spells out that it cannot have retrospective effect. One. So who has already got the degrees, he cannot answer.
That's right, but he reads the other part, the later part.
I'm coming to this. And the other part says that it is not applicable to PhD degrees. I enroll PhD degree. I mean, this petitioner, what is his name? Respondent number 1. She got admitted enrolled in the PhD degree much prior to that. So in 2015, here the confusion arises. I have explained in my article in paragraph 9. She was a master's degree she is an MBA first, my lord. And the master's degree that is required for the PhD is not the MCom, that is the MBA. So that doubt is clear, I believe. So while then she herself enrolled in PhD degree for in a regular mode in 2015. Towards the end of 2019, she enrolled herself in a distance mode in MCom. Now the question arises, while pending acquiring the degree of PhD in a regular mode, whether she can enroll in the MCom degree in a distance mode or not. That is the only issue to be determined by this honorable court. Now the question is, the UGC said, if the PhD degree is obtained through a regular mode, then it is a valid degree. So we cannot touch the PhD.
That is not the issue here, lordship.
No, I'm coming to this.
If it is by a valid mode, by a
regular mode,
then
yes.
PhD is valid.
Valid. So
if PhD is valid, this MCom degree shall not be taken into account.
yes, because her claim is that she should get 13 marks for the PhD degree only.
And which she was not given.
Which she was not given. That is what Learned Singh is.
Lordship,
One more thing, my lord. Suppose, leaving aside all these things, UGC regulations came into place in 2022. Prior to that, what is the regulation? That is the regulation of the concerned university that is in place. Or my lord, there should be a notification from the government higher education that you cannot pursue 2 degrees simultaneously, which has been violated.
If at all that degree, if no 2 degrees, so this MCom degree would be under cloud, not PhD.
Not
Because
PhD,
this
yes.
PhD is pursuant to
Yes.
MBA.
In respect of PhD and MBA, we have.
Now we will decide this now.
In respect of PhD and MBA, there is no issue, lordship. He is claiming on the basis of the MCom degree, lordship.
No, how can that be?
Lordship.
Why? How do you say that?
MCom is the qualification part, lordship.
No.
No, lordship.
The candidate enrolled herself in PhD out of her result
Lordship.
in MBA.
MBA.
There is no dispute, lordship. We never disputed that part. We disputed only part the MCom degree, lordship. On that particular degree, he is applied for the post, lordship.
The subject.
Subject is the MCom, lordship. On the basis of post, lordship, he has applied the particular post, lordship. That is the issue. Even UGC filed the affidavit, lordship, by clarifying everything. We have no issue, lordship.
Where is the affidavit? Where is the advertisement? Where is the advertisement? Show us the advertisement.
Lordship, page 47, lordship. Page 47, lordship.
Where is that? It should be MCom.
And then, my lord,
Where is the qualification? Where is the criteria fixed?
page 49, lordship.
Page
49, Lordship.
49. Yes.
Lordship. Roman 1, Lordship, good academic records as defined by the concerned university with at least 55% of marks or equivalent grade in a point of scale at the master's degree
Well,
level.
reading.
Lordship, page 49, Lordship, eligibility qualification part, Lordship.
No, it will.
Page 49. আমি এসে বলছি গাইডলাইন
Advertisement to it.
অফিস নাম এক্সট্রা
Commerce subject.
Then my lord may kindly come the rejection part, that will be clear, Lordship. Rejection part is page 69, Lordship. Page 69, Lordship.
Yes.
Last para B, Lordship. The primary reasons for less API is that your PhD score has not been counted. You have pursued your PhD and MCOM simultaneously, which is not permissible under the UGC's guidelines.
This is what the reason.
This is the
MCOM. Are you really asking for MCOM degree
Lordship.
for the post?
Lordship.
That is what we wanted to know. At page 49, we don't find it.
Lordship.
Page 47, 49, nowhere it is there.
49 is the Lordship relevant subject.
See,
Lordship.
the relevant subject is
Relevant
commerce.
subject is commerce, Lordship.
So therefore, somebody may have done, just a
Lord-
minute,
Lord-
somebody may have done graduation in arts,
Lordship.
MCOM in commerce.
Lordship. Lordship.
Such things can happen.
Lordship.
Or MCOM,
Lordship.
or maybe PhD in commerce,
Lordship.
and then the MBA.
Lordship.
So therefore, where do you see?
She is not applying in the MBA. Lordship.
Yeah, that a person has to be MCOM. Higher degree is all right.
Yes.
MCOM is the basic qualification for appearing. Where is
Yes.
that?
Lordship, that is the relevant subject. Otherwise, she is not claiming on the basis of the MBA, Lordship. Even Lordship permit, I can place the whole record, Lordship.
No. Please don't get excited.
No, Lordship. I
They're
trust.
actually asking for the reason.
Lordship. Yes.
See, under the UGC rules,
Lordship.
the candidate pursued her PhD before it was prescribed, before it
Lordship.
was avoided. And no retrospective effect could be
Lordship.
given. Therefore, it has to be given
Lordship,
full
Lordship.
effect. Now, after that, she enrolled for MCOM.
Lordship.
MCOM was an additional degree. Maybe she would have thought that she would have some opportunity more,
Lordship.
because MCOM is a subject which is pursued by many
Lordship.
students. So that's another thing. So if you have allowed the person to appear in the examination process, that means you undertook, you accepted the degree of PhD. Is that correct?
PhD,
Or MBA?
PhD degree, there is no dispute. Even MBA degree is also no dispute, Lordship. Only dispute
See,
is
the dispute is not, you did not mark her 13 marks for
13
PhD.
marks because, Lordship,
So therefore, you allowed her to participate in the recruitment process, no?
we allowed her participation in recruitment basis on the basis of the MCOM degree, Lordship. Not on the basis of the MBA degree, Lordship.
MCOM also has been completed.
Lordship, MCOM
So
completed.
therefore, this is what we want to know from this advertisement.
On 22, Lordship, he completed MCOM as well as, Lordship, the PhD, Lordship.
So that we have understood.
Lordship.
MCOM इनका बाद का है.
Advertise,
But you considered her MCOM and allowed her to participate. in the
Lordship, and
examination and did not.
he applied on the basis of the MCOM certificate, not basis of MBA certificate, Lordship. She apply, a particular person.
He is going in a reverse way, but then you will be required to explain. That way he might have a point. You see, you had already passed MCOM. It was only on the basis of MCOM that you were permitted to appear in the
Where is
examination
that mill?
recruitment process. Where is that? We don't know.
Does not say so. In the rejection portion, it is written why it was rejected.
You applied for, the candidate applied for MCOM on the basis of MCOM subject, commerce subject, right? This commerce degree, this master's degree in commerce was obtained simultaneously with PhD. So either PhD or commerce, one only, and commerce for that, and for acquiring a degree simultaneously in commerce, there was no permission.
No, my lord, that is what I wanted to point out. If lordship, 1 minute.
Let's see on that day. Let's see on that. Yeah, how do you?
24 September,
20,
4th September.
sorry, they're different date. 24th, I am out of station.
Ah, yes, give him, give him.
19 September.
13.
19.
Oh, yes.
Item 12 to 14.
Yes.
Lordship may take up WBC 3967. That is
3967.
yes.
That is 13. Item number 13. Yes.
This has been referred by Honorable Single Judge, my lord.
Just let's see this order. Just let me stab not. Body panel, data, number to get complete. I will be living. Yes, tell us. So many numbers of writ petitions and writ appeals.
Yes, Lordship.
One tends to, lose track. You tell us what happened.
The state of Assam has a policy, my lord, to grant advance increment on the procurement of B.Ed degree by the secondary school teachers. And it is started from 1997, my lord. And after that,
It had started from 1997.
yes, for ROP, it is provided in the ROP 1997, my lord. And thereafter, my lord, the finance department has issued one office memorandum in consonance with the, my lord, the ROP 1997 on 7/3/1998. And the granting of B.Ed increment has been continued till, my lord, 22/10/2014. On that day, my lord, an impugn notification was issued by the government of Assam, State Secondary Education Department, whereby it is decided that not to grant further this policy has been withdrawn. That at that point of time, my lord, it was challenged before this honorable court. First, it was challenged in the year 2015. The honorable single judge accepted the contention of the government and upheld the notification. And thereafter, another group of petitioners has put to challenge this without knowing the earlier order. And this honorable court has the subsequent judgment has been allowed, setting aside the impugn notification, and elaborate discussion has been done, my lord. Thereafter, what happened? Pursuant to that order, numbers of writ petitions have been filed, and even it is filed as on now also. And the follow-up orders in consonance with the, my lord, earlier second judgment, it is given. And as a result, my lord, huge numbers of teachers throughout the state have also got it, the benefit. Now what happened, the petitioners hereof, my lord, They have,
Government did not appeal.
government filed the appeal in the meantime with regard to the second judgment. That is closed. That is not decided, decided on merit. That is as intractual, it is closed because those teachers who have preferred the second writ petition, subsequent order, all those have been granted the benefit also. The director has granted. Now what happened, my lord, these petitioners have filed the writ petitions in the light of second writ petition, and orders have been passed by this honorable court, single judge, and thereafter contempt has been prepared. On the contempt, while complying the order, my lord, they have issued that as because the earlier judgment was in negative, and so we shall follow the negative, and now onwards we shall not grant. But it is not the correct fact. On the 18th of August this year, my lord, 18th of August, on the basis of judgment of 2021, this respondent number 3 in another case has granted. I have procured the order. May I please share before worship? As a result, my lord, some of the teachers.
Why did you not challenge that order?
That order was challenged, my lord. Earlier, that order was challenged. But since the persons who have filed a writ petition, they have already been given the benefit. That is why.
It's for future, no?
Yes.
You see, that will apply. It is a one-time increment that you have to give.
Yes, yes.
There are nobody left. Nobody else left.
Left.
From that judgment, nobody was.
No. Are there any other number of teachers who would fall in that category where advanced increment has to be given to them if they have acquired that degree of BEd, even though their appointments were prior to 2012? I don't think you'll have any other number.
Just
a minute.
Yes, sir.
So if that is a fact, then you need not challenge it. Then your notification also is an empty formality. You have given it to everybody. It's one time. And those persons prior to 2012, I mean, when BEd degree was not an essential degree, and if they acquire a degree, then they would get an enrollment. After 2012, everybody who is to be appointed as a teacher has to have a BEd degree.
Yes, madam.
So therefore, this concerns a very limited number of people.
Yeah,
I think I'm making sense to you, no?
yes, madam.
I will follow. So what do you have to say to this?
But,
The issue here is different. It says that the first order upheld the
notification.
withdrawal,
Yes, madam.
upheld the withdrawal, the notification by which this privilege was withdrawn. So this was earlier in point of time. The other single judge did not look at it, therefore it was per incuriam. It could not have been done. And then the appeal against the second order also was closed for whatever reason. In your wisdom, you withdrew it or whatever happened. So therefore, it was all single judge's order. So the division bench ought not to have sent it to us. I mean, it was by single. The single judge sent it to us, saying that a larger bench.
There are persons, madam, who have acquired degree after 2012. They are also claiming a benefit of one increment, madam. They are also claiming it. That is why, madam. That is why, madam.
So all those persons who had BEd degree prior to 3/7/2012 will get one increment.
Yes, madam. But there are persons who acquired BEd degree after 2012. They are also claiming the benefit of one.
None of them have been paid.
Some of them have been paid, madam. That is why, madam, we have heard. That is why
You should have challenged it, no? Or you should have said that on principle this is bad. But whatever has been paid, we will not take it back in accordance with Rafiq Mashi.
in fact, madam, that was the understanding while deciding that rate appeal as infractions, madam. The issue was
When was the appeal closed?
it was closed, madam.
When was the appeal closed? See, the frying ground should have had been that now after 3/7/2012, BEd degree is a must. Therefore, no additional increment is required to be given to anybody.
For the teachers, my lord, who have been appointed.
So what? So what? How many years would you take that advantage?
But the teachers who are here, my lord, they were all appointed prior to 2012. And the honorable single judge in respect of all those teachers who have acquired degree subsequent to that but appointed prior to 2012 have been granted the benefit manner.
They have appointed prior to 2012, but acquired the degree after 2012, my lord.
Page number 80 is the circular. Page number 80 is the circular manual.
Let's call an office memorandum dated 7/2098, before 2012. With this, with 3/7/2012, this should have been written. You have not handled your department well, Mr. When you brought this notification on 3/7/2012, making B.Ed to be compulsory and mandatory for appointment teacher, it should have been your effort to simultaneously withdraw this OM dated 7/3/1998.
Yep,
That's how the logic works.
that OM was issued by the finance department, madam. So that is why there is some,
Finance department had issued that on the basis of the ROP. I mean, it's all right, but the education department would be the controlling department, no?
And page number 80, my lord, your lordship will find a circular given by the.
Shows the judgment of the learned single judge which sustained this
Page
withdrawal of the
76
notice.
is the relevant portion, my lord. Page 76, paragraph 14.
Page
76, paragraph 14, my lord.
paragraph 14.
Yes, sir. May I read, my lord? Now a question arises as to what is to be considered as higher academic qualification. Higher academic qualification is to be understood qua essential qualification prevalent at the time of entry into service. In the context of the amendment of 2012, certainly B.Ed is no longer a higher academic qualification as it is an essential qualification for being appointed to the post of graduate teacher. But there is no denying to the fact that when the petitioners were appointed, B.Ed was not the essential qualification for appointment to the post of graduate teacher. And from the standpoint of the petitioners, acquiring a B.Ed degree certainly results in a higher qualification for them. When the issue is yet to be decided by the department concerned in an appropriate manner in terms of the government official government own notification dated 4/2/2010 regarding justifiability or otherwise of continuance of the grant of advance increment to the teachers for acquiring higher quality.
We want where it was upheld. This is where it was denied. This is the second one.
Yes. No, this is the second one.
So we want the first one.
Oh, first one, my lord.
That is where is the
139, my lord.
in the second one which you have just read out,
yes,
the logic is correct, but the conclusion does not appear to be correct. Then first one is where?
139, my lord. A type copy only, my lord.
139, yes. Reads the relevant portion, MR part.
Also assessing such. In provincialized high and higher secondary schools of the state, and they obtained the B.Ed degree from the Singhania University, Rajasthan in May 2013. It is also submitted that the petition.
What's the reasoning given?
The reasoning will last part.
line starts from my lord. 9, my lord, page 140, prior to the said amendment, my lord. Page 140.
Prior to 2012 amendment rules, the minimum qualification for graduate teacher and language teacher was graduate in arts, science, and commerce with at least second division higher either HSLC or higher secondary examination or equivalent 40% aggregate marks in BSc. Further, graduate with BT.
This is the correct reasoning. There are two aspects to it, Mr. Counsel. One, the OM's applicability. What is higher qualification? Suppose somebody is MA. He becomes a postgraduate teacher or a graduate teacher. Then B.Ed is not a higher qualification. It's in a discipline which is specialized. It is not considered to be a higher qualification. A mandatory qualification need not be necessarily a higher qualification. This is one aspect of the matter. And the entire rationale for that OM, for giving you advance increment, was because it was not an essential condition to have B.Ed degree, but you acquired that B.Ed degree. You were appointed at a time when it was not essential. Therefore, the justification of an increment. But after it became mandatory, why should it be paid to you?
It was, my lord, the second.
Notwithstanding your having been appointed earlier. In fact, the only benefit which should have come to you was that you should have been given a window of 5 years to acquire this degree. That's all. It's all because of trying to help some people, trying not to help some.
Subsequently, my lord, that window was given, my lord.
So what do we do now? He would be perfectly justified in arguing parity. And that is a very, very strong ground. Because larger number of people have been paid. Yet it is very less number.
More than thousands of teachers.
And we are not the kind of court which would ask for recovery of all those and set aside all the.
Obviously, my lord.
That the government also is not interested.
That is why, my lord, the earlier writ appeal preferred by the state was closed as infructuous, and the issue was kept open.
No, Mr. Kadrian, that is the problem. Now you have to suggest the solution. His putting is only on the basis of parity. That's all. And we find the second order of the learned single judge to be absolutely devoid of merit. But you withdrew your appeal. The logic goes very well. See, in the second instance, when the judge says, now a question arises as to what is to be considered a higher academic qualification. Higher academic qualification is to be understood qua the essential qualification prevalent at the time of entry in service. In the context of amendment rules, so and certainly B.Ed is no longer a higher academic qualification, and as is an essential qualification for being appointed for post of graduate teacher. But there is no denying the fact. See, this reasoning was absolutely okay. But then later, I don't know how he diverted. But there is no denying the fact that when the petitioners were appointed, B.Ed was not the essential qualification for appointment to the postgraduate teachers. And from the standpoint of petitioners, acquiring of B.Ed degree certainly results in a higher qualification for them. When the issue is yet to be decided by the department concerned in an appropriate manner in terms of the government's own notification of continuance of the grant of advance, I am of the considered opinion that improved notification. This is what the government had done. Who advises you to do all this? Now face the music now. Have the strain on your purse. But what do we do? You can at least find out how many persons. If there are more number of persons, then we will find out some ways to save you from spending unnecessary. Now, these teachers, all right, we have all sympathies for them. They are the makers of the nation. But then B.Ed is the basic degree they would retire now. Most of them would retire.
They will get hardly benefit for 2-3 years, not more.
In fact, like that.
This is a yearly benefit or one-time benefit?
One-time benefit, but it will
increment.
continue to serve, at least if they get for 2-3 years. Only 2-3 years their services are left.
The earlier order passed by the Honorable Single Judge, that was never placed before the department, my lord.
But,
And department rely on the.
Can you question this now?
No, my lord.
You had the occasion to file an appeal against that order or review or whatever. You filed an appeal, withdrew it.
It was not withdrawn, my lord, but it was closed as infructuous, kept the issue open, my lord.
Where is that? Where
My
is
lord,
that order?
In fact, my lord, I have filed an additional final affidavit in the repetition stage, my lord. It is, I have annex as my lord. Annex.
Where is that order? If the issue is open, we'll decide it.
Yes, yes, my lord. Issue is open, my lord. Department has filed an affidavit, my lord. Annex D, my lord. Case, my lord, 231, my lord. Okay. Oh. 40%. Case
Just a
230.
minute. Paragraph 8, it's very interesting. Now you preferred an appeal. You did not ask for any stay. And you came out with another OM of the department saying that please come, all of you prior appointees of prior, before 2012, come, we are giving you. Therefore, the appellate court said that what purpose would it serve?
But, my lord,
And what issue? Now, after everybody has been paid of that lot, what is the purpose of, keeping the issue open? That is also a justifiable ground by the appellate court to have closed it. You
But-
never asked, did you ask for a stay?
that obviously from
Yes.
the order.
And then you did not even wait for contempt or anything. You did not wait because you had a very good ground in your hand that an earlier order of single judge is against this order with a reasoning. You did not do anything. Instead, you filed the appeal simultaneously. You asked all the teachers to file an application to be paid.
But, my
How do you justify all this? They will discuss it.
paragraph 11, my lord.
And the issue has remained open. Where have you, acted pursuant to this leave?
Well, subsequently, my lord,
And what purpose? Why do we open and why do we start an academic discussion when there would be no beneficiary and no person who would lose out? Why do the courts always refrain from entering into any academic discussion which will bear no fruit?
that is why, my lord, this appeal was closed as infructuous and giving the benefit only to the 41 number of petitioners therein, my lord. So subsequently, my
But what is to be done now?
But in fact, my
You
lord,
don't find anything. Now you have capitulated. You were not in such a beleaguered position then as you are in now. There you had something. Yeah, how many? Just find out and tell us how many more are left.
Yes,
and how many years, then we'll say that you have not done, you have not done. And he has preferred what? Single. Look at this. Now you are not suggesting us the ways. Now question the reference now.
Yes.
Question the reference, the referral order.
Yes, ma'am.
Do it. The division bench had already decided. Where was the question of reference? Now you can succeed
But-
only on this, not on anything else.
Division bench did not decide the issue, my lord. Regarding the,
Mr. What is his name? Mr. Khataniar, you don't understand what we tell you.
yes, ma'am.
See, you have created a situation, an impasse where you cannot be bailed out.
That I understand, ma'am.
You have done that. On your own, you have asked
Yep.
students, you have asked teachers, you have paid. Now, this reference came pursuant to some direction by the university, by the department, that these persons will not be paid. That is ununderstandable. And single judge says that why go to division bench. So therefore, you have to
Because, my
challenge
lord,
the
this first order of the honorable single judge was never placed before the authority and also in the subsequent division bench also, my lord. We have challenged the order of the second order of the honorable single judge, but not on the ground that there was earlier order passed by the honorable single judge. That is why, my lord.
That's all right.
We have came to know about the earlier judgment
Where
subsequently, my
the
lord.
referral order. Referral order means the order of justice Phuket.
Yes.
You tell us where has it been made known to him that division bench has decided the issue? The only ground available to you is to question the referral. Then we leave it.
But
Otherwise, we'll say something strongly against you.
in my humble understanding, my lord, the division bench has not decided the issue, my lord. But
So far as the issue is concerned, it has decided the issue. It has said that you yourself have offered, why would the court take it back? You want to give, you give.
But subsequently in paragraph 11, my
So
lord.
question open, the question has been left open for doing what?
Yes, my lord.
For a general academic discussion,
Yes.
what is a higher qualification? And higher qualification is always qua the basic qualification. Now suppose for a graduate teacher, a graduate degree is necessary. Now somebody acquires MA, degree of MA. Would it be considered higher degree for taking that thing? Could be, because it is higher qua the minimum. Right?
Yes, ma'am.
So B.Ed is higher qua the minimum. Not higher, a specialized training. Specialized is always better. So therefore, the issue has remained completely academic. We don't get into all this academic. Tell us the number now. If the number is large, we might rake up our minds.
Yes, ma'am.
You understood?
I got ma'am.
Then we refer it to the single judge again. Referral is not considered to be correct. It has been decided. That is the only way in which you can save yourself. Otherwise, you're inviting very serious comment on your working. We understand that you have paid the teachers only. There is nothing bad about it. But then continue the talking.
Yes, ma'am. I'll get the number, madam.
At the instance of Mr. Khataniar, an advocate for the respondent, the matter is adjourned to. We are giving you 2 weeks. Tell us, we can't leave it pending like this.
Yes, madam.
Tell us the number.
Yes,
Have the statistics with you. How many more will be required to be paid? If there are few, we will not enter. If the number is large, which I doubt, those are less.
Very few, madam. Very few.
We are absolutely not in favor of granting this additional increment to the teachers. Let them acquire that degree, but now it is the basic minimum degree. Why should they be paid?
Exactly, madam.
For their remaining in service, it is necessary. Everywhere, if you, find out from the decisions of the education department in other states, a window is given only for acquiring the higher degree, which becomes the minimum degree. Unless you do that, your service is dispensed with. Instead, you are giving an open-ended liberty to them to continue.
Subsequently, in the year 2014,
And then
that was given, my lord.
is it not, does it not run counter to Article 14? Now, persons who have that degree but appointed after 2012 will be getting less. Yes. Anyway, Chali, find out the number and tell us.
18 September.
No question. Let me first tell. Let me be quick. Mr. Patniar will say something. A peculiar situation has arisen in this case, leading to referral of these writ petitions to a division bench by a learned single judge. Prior to 3/7/2012, B.Ed degree was not an essential qualification for being appointed as a teacher. And as such, any teacher having acquired the higher degree when it was not mandatorily required, he was given one advanced increment by office memorandum dated 7/3/1998. Stop. Later, when the B.Ed degree became the mandatory requirement for appointment of school teacher or for appointment of teachers, the earlier notification was withdrawn by notification dated 22/3/1998. This was challenged by some of the teachers, but the challenge could not be sustained, and the withdrawal and the OM withdrawing such benefit was upheld. It appears that later another batch of teachers filed another writ petition challenging the said notification dated 22/10/2014, bracket notification of withdrawal, which in this instance was set aside without noticing the earlier decision by a single judge. Though the state preferred an appeal against the latter judgment, but simultaneously issued another advertisement, issued another notification asking the teachers to make application for payment of additional benefit as the notification had been quashed. Thus, the appellate court, finding that the state of its own had given the benefit to all concerned, closed the appeal, but left the issue open for left the issue open whether acquisition of B.Ed degree could at all be considered to be acquisition of a higher degree, as a higher degree is the minimum qualification for a particular post, and whether any person appointed prior to the requirement of a mandatory B.Ed, what have I said, and whether would ought to be paid any special increment for acquiring the B.Ed degree now when it has been made the essential qualification for appointment of teacher. It appears another batch of teachers who were not paid the additional increment even after they had acquired B.Ed degree, and their appointments were prior to 3/7/2012. That matter, that case, the learned single judge, while hearing that case and noticing the two judgments with divergent views, thought it better to refer the matter to a division bench. Hence the referral. Next paragraph. However, while referring the case to the division bench, the learned single judge did not consider an important aspect of the matter, that against one of the judgments sustaining the withdrawal of notification, granting additional benefits to to appointees prior to 3/7/2012 acquiring B.Ed degree, was that the appeal against was, no, how have I said? What have I said? I just missed out. The appeal was filed, but was closed on account of the fact that the state government in the education department had come out with a notification asking the teachers to apply for additional increment, as the notification of withdrawal had already been quashed. In that view of the matter, the issue was not required to be referred to a larger bench, that is a division bench in this instance. Nonetheless, we would like to know as to how many persons more are left who would be the beneficiaries of such decision of the government of paying one increment to appointees prior to 3/7/2012 on their acquiring B.Ed degree. For us to justify, so on, re-notify on so and so date.
18.9. Item 15.
What happened? That sidewalk and all that.
Yes, still now it's in the same condition, Lordship, in a pitiable condition. Yesterday photographs were being taken.
Lordship, in this case, I am appearing for the state lordship.
We are pointing at the state, no? Since I don't know you, I cannot.
Lordship, I'm filing one affidavit today, Lordship, but so far as the issues are concerned, Lordship,
Where is the affidavit?
affidavit I'm going to file today.
What steps have you taken?
Lordship, we have, in our stand is that so far as two roads are concerned, one is Lakshminath Besborua Road, another one is College Hostel Road. From the police point of view, Lordship, in both the roads, Lordship, no working boat has already been.
That's a statement.
And
This
we
is
are
just an oath against an oath. The lawyer has gone there. She has seen it.
The board is still there.
You
No
want
parking
you want the court to appoint a commissioner. I mean, we trust the government agency.
Yeah.
So why do you have to file this kind of an? Let's see what is the affidavit. When would you do it?
One affidavit I am filing today itself. So far.
Again, Mr. Naik, learned advocate for the state, seek some time as the affidavit in response, though has been prepared, but has not been filed. It is likely to be filed shortly. List this matter for consideration on after 1 week. They are blind students, therefore we are giving a short date.
Lordship.
You must do something, no? At least parking vending zones you have to remove.
Lordship, one area is a notified vending zone. That is the difficulty we are facing, Lord.
You have to do something, no?
But in other
There is no tactile path.
Yeah.
There is nothing parking, how do you expect people with sticks to walk?
Yeah.
I mean, you have to do something. I mean, I'm not asking you to remove the vending zone. That again impinges on their right to livelihood.
Yes.
But do something so that
But
they
in the-
have
in
a
the-
safe passage.
In the other road lordship, we have already evicted.
Have you said that?
Yes, in my affidavit time.
What did we consider?
19 September.
Don't mistake us. We are not asking you to remove the vending zone. Unless you have made it in the middle of the road.
Yeah.
Unless you have made it in the middle of the road, we are not asking you to remove that because that's against that would be pursuant to any policy decision which is continuing. But at the same time, you have to devise ways so that these blind students could go to the campus. That they're taking so much of efforts to study. And we must, as citizens, we must provide them that.
I understand.
And you're a welfare state.
Lordship.
And so are we because we are administering law.
Lordship.
Correct?
And I.
All.
Obliged.
Item 16 on 19/9.
As per the last order, they are supposed to file affidavit.
Yes, my lord, I have got
Otherwise-
the instruction, well, I will be filing it by tomorrow, or I will try to file it by today itself, my lord. But some, my lord, development has taken place, my lord, during the pendency of the writ appeal. The learned single judge, my lord, in the order, has stated that, my lord, it is a government will take a call regarding the, my lord, qualification criteria for the, my lord, grade 4 employees for their promotion to the next level post of junior assistant. We have taken a decision, my lord, it will be now graduation. And none of the writ petitioner as well as the.
Would it satisfy anybody?
Yes, my lord, there are, my lord, so far as the present, my lord, petitioner is concerned, or the read appellant and the private respondent, both are undergraduate. In fact, my lord, that
And
amendment.
you are going to make what amendment? That they have to be postgraduate.
No, graduate.
Graduate. Both are graduate.
Yes, both are undergraduate. So now, in fact, that is the decision of the learned single judge initially. In fact, my lord, in 2015, that amendment came.
See, the first order when both of them were checked out,
Yes.
that was correct. But
Otherwise.
later in review, I don't know what happened. So
Review
that you
allowed.
must do.
No, reviewed, my lord,
Review
in the
allowed,
sense
my
that,
lord,
my
they
lord,
can
there
make
was no
petition
decision from our side to show that it will be graduation.
Anyway, what do you want?
I will file my affidavit, my lord, into record this part. my lord. I can file it, but tomorrow, my lord, any day, my lord, next week.
Mr. B. Gogoi, an additional advocate general, seek some time to put in his response to the memo of P. So let that be done by the next date, re-notify. So
This appellant was promoted in the year
That
2018.
has been interfered
So
with.
18 record will be necessary. How they promoted?
all right. Let that be there in
Yes.
your affidavit.
So that time only one was.
If you have come out with a new notification or you're contemplating, then perhaps that may not be required. Both
No,
of
my
them
lord,
will have-
already the government has clarified. I will place it. in
That's
my-
all right, that clarification, but give a window to them to acquire that degree. You can't check them out now.
That part, of course, my lord, something comes up from this honorable court, it will be more convenient. my lord.
Give it to us, then we will see.
Yes, sir. I will file my affidavit.
Otherwise, they are serving you for so many years. You
Lordship.
can't just make
Yes,
a,
yes, their entire revenues to promotion will go. my lord.
give them the window. That's the procedure adopted by most of the state governments.
Lordship. My lord.
22nd September.
No. Hey, get up. Relax it up. Oh, no, you know, 19 and 20. You might quickly. Go ahead. Chalo, call. Second half.
Item 19.
Yes.
Let me say, Lordship.
19 also my senior counsel lordship can settle the appearance. Possible lordship tomorrow.
Who appears? Who leads you?
The KN showed
I was here to rush. We saw.
He was in different purpose, election different.
Second half,
That
after one, after two.
Lordship, there is one difficulty. Lordship, I am appearing as standing counsel in this case of PF organization, but I have not been server copied. If the server copied, your Lordship, any day. At two, it will be difficult. I'll leave this.
The standing council for the Provident Fund. Learned council for the learned council for the Provident Fund. क्या है? What is the organization name? AE. Provident Fund, what is it?
ATE, Assam Tea Provident Fund, Assam Tea Employees Provident Fund Organization. ATE,
Learned council for so and so. Has submitted that he has not been served a copy of the brief. The land counsel for the appellant submits, the land counsel for the appellant assures that a copy of the brief shall be served upon the counsel or so and so. Let that be done during the course of the day.
Lordship.
List this matter for consideration on after 2 weeks.
No, Lordship, some urgency is there, Lordship, because
Next Monday.
Next Monday.
obliged,
8-9.
obliged.
Item 20.
May it please, sir.
Yes.
Lordship, can this matter be taken at true or fast for the day?
Why, what happened?
Lordship, I'm not in this case. My senior is like for 3 years.
He was here. All right, we'll take it up at 2.
Some other day, your lordship, too.
Let us come to court at 2. You seek adjournment. Let
Lordship,
us
lordship.
come to the court now.
Deeply.
Mr. Chaudhary, you were here, but you had to go. We could see that. So he adjourned the match.
I can surprise me.
I saw that. Yes, what is this?
Lordship, this PIL is with regard to that Brahmaputra Carbon Company Limited, Lordship, which was initially, because later on when in our petition we have pleaded that it's a residential area, but later on through RTI, when the respondent has filed the reply, through RTI we came to know that initially it was a residential area, because in 1967 we have annexed along with our in our one of our affidavit that one LP school is established way back in the year 1967. And subsequently in the year 2000, that area was declared as industrial area, not prior to that. And the company, that Brahmaputra Carbon Factory, it was started in the year 1996. As per right now also we have checked in the Google, it says that established in the year 1996. And in 2000, this area is declared. In our last affidavit, as per this honorable court's order, we had filed lordship. Yes.
Now, leave the affidavits aside for now.
Yes, lordship.
Tell us what is the issue.
Issue is because of the carbon molecules which are coming out, emission coming out from the factory, which is creating a problem for the residents, which health hazard, one. This is creating problem for even the children, because nearby, just opposite to it, there is an Anganwadi center where children cannot come out, because when the factory is on, then what happens? The carbon molecules, and when we did the fact finding, recently we came to know there are 2 motors in that plant is there. If that is used, then carbon emission is less, but that is not used. Reason is that electricity consumption is more and the electricity bills are high. Usually where they have 2 plants, where if those plants are being means it's in operation, in those plants, the carbon emission, this thing is much lesser in the air, which will help, not health hazard will be less. But they don't use. One reason is that because of electricity consumption and because of the bills. And the hazard which the people are facing in that locality is even within 2-3 years, they have to change the tin roofs because
Now,
of
tell
this.
us what have you prayed for?
We had prayed for lordship. Page 24, lordship.
Any factory would be bad for the climate and environment. But then we have to see what can be done.
Yes, lordship. Definitely, because it's this factory also is giving livelihood for the locality. That also we admit, because many people of that locality are being engaged in that factory. But our concern is that children are there because just opposite to it, one of the gate of the factory, there is an Anganwadi center and the primary school is there, Lordship. LP school is there, which we also have annexed.
Who appears for the pollution control board? What do you have to say?
Already our affidavit is very clear as regards that amount of pollution that are being to be visible and executed. So we have done the analysis report and we have done time to time checkup of all the parameters that are being exposed to the.
Where is that? Where is your affidavit?
In the very clear. We have filed way back in 2026.
Where do we get it in our brief?
That's really. That's for the page mark of the book.
Lord, as far as the affidavit opposition filed by Pollution Control Board, Lordship, we kindly have a look at para 6, 8 and 14
Oh,
of the affidavit filed.
we are locating the affidavit. Is it at page 53? The affidavit dated, affidavit is on number 6. All right.
Our information are.
All right, we have got it. All right, we could get the affidavit.
Yes.
But which paragraph are you?
Para 6, 8 and 14.
All right, just a minute. Okay, let's see the reply. To this affidavit, Madam Ghosh, you have applied, you have replied, isn't it?
Yes, as per the Honorable Court's order, Lordship, I had filed on 1/4.
So I can see that there is some reply to this.
And police to file. Police.
If they are not feeling guilty, but then it can become completely. Who is Amit Kumar Hajong?
That's my colleague, Lordship.
Be correct, Mr. Coach, but what to do? We are in a quandary, what to do? You are right.
And another one
But
aspect.
one must reckon that any factory anywhere,
Yes, Lordship.
it emits carbon in the air.
Yes.
Can we stop it? That's one thing, because I see we have found that it is near a school, Anganwadi center and all people.
Yes, Lordship.
So you don't suggest a shutting down.
So that also another, if it can be shifted somewhere or even
Shifting
the,
also is difficult, but then they must conform to the rules.
and yes, Lordship, another one.
Where is, had Mr. Chaudhary, you appear for the Brahmaputra?
Lord, the petition is structured on the basis that this unit has been set up in a residential area.
No,
That is wrong. That is in fact a false statement. I say it's a wrong statement.
That's an erroneous statement. Not a false
Now,
statement.
Lord, it was set up in an industrial unit. There was a consent to establish given by the Pollution Control Board. Then consent to operate, all operational requirements have been complied with. Time to time, it is being inspected. And my latest consent to operate is up to 27. They give for a particular period. Thereafter, they will again will not make an inspection, then they will.
Now, but Mr. Chaudhary, tell us one thing.
Yes.
Consent to operate also puts an obligation on you to prepare a green belt, to develop a green belt of 50 meters around.
Not whatever,
Have you done?
whatever requirement has been envisaged, we are complying with.
No, have you done that?
Yes, yes. Or else pollution control board would have come up.
Pollution Control Board is totally in your favor, Mr. Chaudhary.
Question of in favor. These are all set up by our competitors.
That's right. That's right. All have been set up, but Pollution Control Board. The
In
matter
fact,
should
Lord,
have, they
my
should have
learned
taken.
friends have taken time.
Now, how about this suggestion of your not running two units? I mean, two plants which would cause less emission. What is that?
My learned friend has made a submission that we have installed more machinery to curb that emission, my lord, but because it consumes more electricity.
Yes,
we
that's
cannot
what,
use it.
that's what we
What
understand.
is the basis, my lord?
So is it incorrect?
No, it's not correct. How can it be correct, my lord? We deny that. Lordship will kindly appreciate the idea was at least on 7 to 8 occasions, my lord, my learned friend took time to file affidavit to bring to the notice of the honorable court the health hazard which is being caused. She has not been able to file that. Can you see the order sheet?
Chaudhary, this is, I mean, you may be seeing it as adversarial. I am not seeing
No,
it as
it's not
adversarial.
adversarial.
The question is that this advocate, I mean, she has pulled in the efforts of all her colleagues and she's doing it. She doesn't reside there. She's doing it very passionately. And she has brought in many information. Carbon emission has to be the name of the company suggests. So
Only thing is,
whether it is within the
let
permissible.
them make a periodic check, my lord, let pollution control board make a periodical check, my lord. We are bound by the norms, my lord. We are bound to follow. It is none of our case. Every 3 months, let them check, my lord. Irrespective of whether there is a requirement or not. If they suggest any new measures to be installed, we will do.
Who appears for the state?
I am for the state, but at the moment I'm very.
No. You appear for the state, but now we would like the state. What is the, I mean, is there any policy of changing the Anganwadi centers because of construction of new building? Or
First of all, that is to be ascertained also. Let us merely, that can be ascertained.
yes, I mean, Ghosh, what can be done now?
My lord, in fact,
No, we
on
can't.
12
This-
I personally also has visited that
That's
area.
true. But then
In fact, with
you
my
don't deny-
colleague
you
who
don't
is
deny
beside
that
me with him
you do.
and my.
That's right. We understand. We appreciate your effort. We appreciate it absolutely. But tell me one thing. This allegation of yours that it is in residential area. Is not-
That I have stated. Now it's not residential. This I have clearly stated in my this 1/4 affidavit. Lord.
Now thereafter,
Yes,
the
Lordship.
Pollution Control Board certification
Yes, Lordship.
and their finding. Now you have made efforts. You have found out from people whom we don't know, and we ask it to be shut down.
We are not.
Shifting is very difficult because it has to be shifted to a place. Shifting and uprooting would cause immense problems. We are not bothered about the company's
Understood. I
management,
understood, Lordship.
but for the laborers, the workers,
Yes.
maybe of the local area.
Yes.
And then it has to go to some place which is designated for factories. It will be totally uprooting it. Shifting means stopping the production.
Yes, Lordship.
Completely shutting down. What else do you expect the government, the courts to do in this situation?
And in fact, one of
Now, would you agree or not with us that even flying off so many cars on the road is creating health hazard?
yes.
Is it not? Can we stop
Yes.
it?
No, Lordship.
Now we can only control it.
Yes, through every year we have to
And the
renew our
government is
pollution
doing
in
its
this
best
thing.
to ensure that Bharat 2 model engines
Yes,
only should
Lordship. Yes,
operate 10 and 15 years
Yes,
would be phased out. But what to do? There has to be a balance, no?
Yes, Lordship.
Now, in view of this report of Pollution Control Board, we are helpless. We do appreciate you stay anywhere near, staying on a main road. In fact, I can tell you, despite
Yes,
that
Lordship.
green belt in front of the House of Chief Justice, because of the traffic, I find that there's smoke. I can't open my door in the night.
Yes. Green belt also. I think green belt and Lordship, two things if Lordship permits, I want to state is that green belt is.
No, we are asking you repeatedly if you have any suggestion to make which will
Yes,
which
help.
will let me go thinking. Make a suggestion. We are not very happy closing down this petition, but there are good reasons for us now,
Yes,
sitting on
Lordship.
the judicial side, to close this petition now for some other time. But you suggest what can be done?
Lordship, one thing is that green belt also in front of the vicinity of the
That's what I
Anganwadi
asked them.
center. And there is also lacking on their part also.
That is
green
what I
belt.
asked them. They say that yes, that because before the consent to operate
Yes, Lordship.
certificate is given, it has to be ensured by the authorities, both the statutes which are in operation.
Yes, Lordship.
It has to ensure that there is a green belt. So if you deny that there is a green belt, we'll immediately ask them to do it within, say, 20 days, 30 days. They have to import trees, they have to plant grass, immediately it shall be done. Point out and tell us. But
Yes,
otherwise,
in both also in the school, Lordship, it can be done in the school because then the children can play in the playground of the school. Otherwise, they have to have the tiffin
see,
inside.
that we can always ask them, but would it be okay?
Not with, at least the government to
Would it
plant
be okay
trees.
to ask them to, invest? They're not a public sector organization, they're private organization, private company.
Yes.
Now, can we say
Government to
no, that is that we will leave it to their good sense.
Anything is there is shortcoming, we'll definitely undertake.
We will.
And another one aspect is there, whenever inspection comes, those two plants which I have stated, I have made a submission, they start so that the emission is less.
No,
that has been
that has been completely rejected. The information appears to be
which the employees, because if we go through the report, which I myself also have interacted with the people of that locality, because not only with my colleague, I also have visited that area. They have stated they don't want to reveal their name because they are working in that company. In that vicinity, we ourselves has gone there. We took the effort after the honorable court's order.
Why would a company shy away from using some plant or machinery which would
Being installed.
after installing it? What was the purpose? What is the purpose of keeping it?
Because of they said that because the people with whom we have interacted.
So one suggestion we have taken, I think it is agreed to by Mr. Chaudhary. We will say that in our order. Any other suggestion? Do we close this petition now? What do we do?
Yes, I will leave up to law.
The lodgings and permission, can I take leave?
Please, but we will give that undertaking from yours.
Green belt part.
In your absence, some junior of yours, he should be able to tell you what we have.
My friend would be there.
Thank you.
Before your right, may I add one more point? So in our consent to operate, so there is a condition down below whereby the industry has to give their compliance report by 15th of every April, every year. So where all these conditions are enumerated, including green belts and establishments of all other pollution devices. So they have to give the compliance, and accordingly we make a visit and we just report. So green belt is also part of it.
That's right.
Yes. And the only thing is that let the pollution devices be operative, as he has said that only during inspection it is operating. So at least that will serve the purpose of reducing the pollution.
No, that we can't say that. No, you just kept quiet when Mr. Chaudhary was here, and now you're suggesting this.
No,
you can't do this.
His
representative is there, but see how he denies. He denies that this is.
And Lordship, one humble prayer. If prayer number 1 can be allowed.
What is prayer number 1? Read prayer number 1.
Read in the nature of mandamus and or any other read of like nature to be not issued, directing the respondent authorities to form a committee of experts to assess the impact of.
Now that would be asking for a supernumerary committee over and above the pollution control board. We'll ask them to do the needful thing.
Yes,
that would be showing no trust on the body. Unless we hold that they are not doing the work, they are making wrong statement, they are not correct. How do we create a body?
No, I understood. Here, my submission, whenever they get the information, then the machineries are.
You're right. The workers will not say a word, otherwise they'll be retrenched.
Exactly, Lordship. This is the thing.
But then what?
This is the reason, even in our report, interacting with it, we didn't mention the names. They said that we are ready to tell, but please don't mention the names.
That statement is neither here nor there. We can't.
Yes, I can understand, Lordship. We tried our best to project before this.
You have. We are absolutely happy at your efforts. That we are closing the petition does not mean that it was a frivolous petition. It did send us thinking, and we are not very happy closing it. We could have continued with it so that the sword would have remained hanging on their heads. But then it is no great fun otherwise. Take the. We have heard MSD Ghosh, assisted by Mr. I. Chakma.
SK Chakma.
SHK Chak.
Yes, sir.
I. Chakma, learned counsel for the petition. And Mr. Kane Chaudhary, led senior advocate for respond number 1. Respondents number 3 and 4. Mr. S. We have also heard Mr. S. Barua, Standing Council, Pollution Control Board. The present petition has been filed by concerned residents, highlighting the environmental and public health hazards which are being caused by Brahmaputra Carbon Limited, a company incorporated in the year 1996. A factory appears to have been set up at Dalgaon under Bongaigaon police station in the Bongaigaon district, Assam, which is described as purely residential area. According to the petitioners, the operation of the said factory has resulted in serious environmental degradation and has adversely affected the health of people living in the vicinity. The factory reportedly discharges harmful pollutants in the surrounding environment, thereby creating air and possibly water pollution. Despite continuous and multiple complaints lodged by local residents over a period of time, no action has been taken. It has also been submitted that on 3rd of February 2022, the petitioners had submitted a formal representation to the Deputy Commissioner of Bongaigaon, urging the formation of an expert team to investigate the functioning and environmental impact of the factory. But no action was taken on this representation. The inaction of the authorities, it is argued, is arbitrary and in violation of statutory obligations. So far as evidence of the harmful effect of the harmful impact because of the functioning of the company, the petitioner has drawn the attention of this court to the news reports and some visuals displayed on public platforms regarding the suffering of local populace because of the harmful effect of the emissions from the factory in question. The petitioner laments that despite the existence of comprehensive environmental protection laws like Environment Protection Act 1986, the Water Prevention and Control of Pollution Act 1974, and the Air Prevention and Control of Pollution Act 1981, the plight of residents nearby have not been able to be redressed, have not been redressed. This is attributable to the apathetic approach of the authorities. Such ecological, such environmental hazard, it has been argued, is counter to Article 21 of the Constitution, which provides right to life, and it includes within it the right to a clean and healthy environment. The complaints, it has been further asserted on behalf of the petitioners, has been left unaddressed because of lack of enforcement by the authorities. In reporting the matter or monitoring and regulating, and thereafter taking corrective measures against any polluting company. This court had called for an affidavit from respondent number 6 / Pollution Control Board, PASAM, to respond to the aforementioned allegation. The affidavit filed on behalf of respondent number 6, however, indicates that the accusation made in the petition is absolutely incorrect. There has been no adverse impact of the running of Brahmaputra Carbon Limited. In fact, the Pollution Control Board had been regularly monitoring the level of pollution created by the company in question. But the reports indicate otherwise. The analysis report of the Stock Commission monitoring done by the board officials on 6/4/2022 reveals that the emission parameters are under permissible limits. The company was commissioned in the year 2004 for the purposes of production of calcinated petroleum coke. For arresting the particulate matters emitting through the production process, pollution control equipments like Venture Scrubber has been installed in the plant. Dust collectors also with chimneys have been installed by the unit to arrest the dust particles at source. So even the emission of gases, the report indicates, are within the permissible limits as fixed by the Central Pollution Control Board. Central Pollution Control Board. So far as the accusation of the company having been set up in a residential area is concerned, the petitioner does not press it, as admittedly it has been set up in a in an industrial zone after all clearances from the concerned authorities. The affidavit of respondent number 6 further indicates that only after being satisfied that the latest pollution control measures / devices have been installed by the company for effective control of pollution, the consent to operate was given. And and this is no one-time measure. An yearly assessment is made. And in case it is found that that there is any emission of gas or pollutant which has crossed the approved parameters, necessary action shall be taken. Though in response to the aforementioned affidavit, the petitioners got a survey conducted wherein it was found that the residents of the locality have been greatly distressed because of emissions from the factory. It has also been urged on behalf of the petitioners that the fact that there is a Anganwadi center and school situated nearby can always be verified. The already fragile atmospheric system, the already fragile atmosphere around the area has been made worse. However, even after having said that, MS Ghosh, Learned Counsel for the petitioner, admitted that running of a factory, setting up and running of a factory in a zone in a zone dedicated for setting up of such factory is also beneficial for the employment of local people. In fact, most of the local people are engaged in the aforementioned factory, which has a very high productive capacity. Shutting it down is no way. Shutting it down would not be, shutting it down would be counter-effective. However, what MS Ghosh desires this court to direct that the Pollution Control Board keeps on monitoring the factory at regular intervals and ensure that all the requirements for operating the unit are continuously fulfilled by the management of the company, like maintaining a green belt in and around the factory. She has further suggested that if in the nearby school also a green belt would be established with the initiative of the company / factory, it would only reduce the impact of atmospheric degradation as a result of running of the company. Mr. Kane Chaudhary, senior advocate, was appeared for respond number? Was appeared for respond number 3 or 4. Readily agreed that if at all it is indicated that any green belt has to be set up in a nearby school or in the Anganwadi, which could be used by children of the locality, the company would be more than willing to initiate that process and have such green belt set up. Louis Edric Bigogres, an environmentalist, has very rightly observed that grass and sky are two canvases into which the rich details of the earth are drawn. The courts of the courts of the land have always paid special attention to problems of air pollution, water pollution, and environmental degradation, and have passed a number of directions and orders to ensure that environment, ecology, and wildlife be saved, preserved, and protected. All this has been done because of the court's interpretation of Article 21 of the Constitution, expansively incorporating in it the right to have the enjoyment of quality of life and a clean environment. Refer to Subhash Kumar Yadav versus State bracket. Subhash Kumar Yadav versus State of Bihar, 1991, 1 SCC 598. MC Mehta versus Union of India, 1988, 1 SCC 471. Velour Citizen Forum, Welfare Forum versus Union of India, 1996, 5 SCC 647. AP Pollution Control Board versus Professor M.V. Naidu, 1999, 2 SCC 718. SR Oil Limited versus Halar Utkarsh Samiti, 2004, 2 SCC 392. That's it. The petitioners have made laudable efforts at bringing to the notice of this court the difficulties of the residents and the impact of the factory on people. Impact of the running of the factory, the adverse impact of the running of the factory on the local residents. However, the question remains as to whether shutting down the factory or shifting it to another place would be viable. As noted above, the factory has been set up in a special zone meant for establishment of such factory. And the laws controlling the pollution have been adhered to. The affidavit of the Pollution Control Board makes it very obvious that all safeguards have been followed. The company has also agreed to build, to develop a green belt in the nearby Anganwadi center and a school which would only facilitate the children of the locality to have some green space for them to breathe and play, We therefore find it apt now to close this petition with a direction to the respondent Pollution Control Board to keep on monitoring the impact, and making impact assessment at regular intervals. And in case of pollutants / emission from the factory, increasing the emission, going beyond the prescribed parameters, take action immediately as provided under the relevant statutes / act. We would appreciate if an effort is taken by the factory, by the company at the earliest, for establishing a green belt in the Anganwadi center and the school. This court hopes and trusts that with such measures, the people of the area would have some respite. We have said so also for the reason that there is no dispute about the fact that most of the local persons have found their employment in the factory in question.
One small suggestion, Lordship, if Lordship permits me. One is that because they do health checkup for their own staffs, employees over there. If health checkups can be done in the school, one reason is that their corporate social responsibility also is there, that they can show.
Take that responsibility. उसी में जगह पर कहीं पर लगा देना. Another suggestion made on behalf of the petitioners that while doing the regular health checkup of the employees of the factory, if such exercise, if such health checkup could be done of the students of the nearby school, it would go a long way in mitigating the harmful effects of the rest. The learned counsel appearing for the company agrees to do so. Who's in नीचे में जो लिखा है with the hope and trust that green belt and this regular checkup will include these persons. Thank you. We are happy at the efforts.
Deeply obliged, Lordship.